Hello again. This is Estates and Trusts. It's the online module about class gifts, and I am Professor Donna Byrne. Okay, in this piece we will be describing and applying rules about closing a class, and we will try to identify and correct some ambiguities related to class closings. So first of all, a little bit of review about future interests. We made a distinction between a vested future interest and a contingent future interest. So if survival is a condition, then the interest may well be contingent. For an interest to be vested, remember, the beneficiary had to be born, had to be ascertainable, and there couldn't be a condition precedent. And otherwise, the interest was contingent. So if you think back to Swanson versus Swanson, Benny's interest was vested. He was born, he was ascertainable. In fact, the will named all 9 children, and there was no condition precedent. Now, there was a condition subsequent that could divest him, but the court said that hadn't happened. Okay, now there's also, you may recall, we made a distinction between remainders and executory interests. Now, the restatement eliminates this distinction. It just calls everything remainders, whether they're truly remainders or executory interests. What was the difference? The difference had to do with how the interest before the future interest came to an end. The Uniform Probate Code makes all future interests contingent on survival until the distribution date. Okay, so those are the restatement, of course, is not a statute. It only matters if a state has actually followed it. But it does describe the direction of the law, and it chooses a best practice. Now, in spite of these more modern changes, I want to suggest that this distinction that we made between remainders and executory interests might be helpful part of the time. Executory interests are always contingent, and not just on survival, they're always contingent because we always need some condition subsequent that will cut short that previous interest. Remainders, on the other hand, can be vested, as was Benny's in Swanson versus Swanson, but they might not be. And so even though there's a UPC rule that treats them all as contingent on survival, for purposes of where we're going, which is ultimately the rule against perpetuities, that contingency can be very useful to identify. And, of course, we can always draft around a statutory presumption. Now, a vested interest, like Benny's, can become divested if there's a condition subsequent, something that could happen to take it away. And sometimes we call an interest that can be divested defeasible. So remember Benny again? His interest did not become divested because the court said in order to become divested, he would have had to die before his parents and leave children, and he didn't leave children. I'm sorry, I couldn't resist this. That's Di, Lady Di, Princess Di. Actually, she was Lady Di at the time, wearing a vest. May well be the last vest she ever wore. I don't think any of her princess pictures had vests. Okay, class gifts. Now, think about gifts to individuals and contrast this with a gift to a class of people, such as children, descendants, or the William Mitchell College of Law class of 2013. Right? That's also a class for our purposes. Notice that classes could revolve around family affiliation or something else. So when a class revolves around a family connection, it's easy to see how closing the class could depend on biology. Make sense? Okay, it used to be easy to see how closing the class could depend on biology. Of course, adoption is always a possibility. Remarriage is always a possibility. So closing a class biologically kind of requires everybody to die. When the class involves some event, on the other hand, it's clear that some other contingency, other than being born, is what matters. And so with our 2013 William Mitchell class, we need people who graduate, from William Mitchell, not some other law school, and in 2013. So it's often easy to predict when we'll be able to close a non-family class. So in the William Mitchell class, by the end of 2013, right, or probably in May of 2013. Actually, I don't know how we label our December class, the ones that actually graduate in January. In any case, it's 2013 or 2014, one or the other. All right, we have a rule of convenience. This can save us, in the case of a biological class, from having to wait most of a lifetime in order to take possession. Sometimes those family-related classes can take a long time to become certain, to become closed. So here's the rule of convenience. When any member of the class has a right to demand possession, the class closes. Okay, so that means that it's time for the trustee to write a check if there's someone available, and there is someone available. So status is everything, right? If the class is children, who is a child? If the class is descendants, who do we mean by descendants? Issue? Spouse? Oh, yeah, okay. Spouse is not likely to be a class, but children and descendants are very typical classes. Let's look at First National Bank versus King. In this case, is a grandson's adopted child one of the testator's lawful descendants? That was the term in the trust. Now, if you use the term lawful descendants, what would it mean? As opposed to unlawful descendants? Well, state statutes, we know, generally treat adopted children the same as biological children. And Illinois, in fact, had such a statute. It was enacted in 1975, revised in 1989, and it creates a presumption in favor of an adopted child. It's a rebuttable presumption, though. So it's rebuttable if the intent to exclude such child is demonstrated by the terms of the instrument by clear and convincing evidence. So here's our situation. This is Lewis F. Swift. Sr. died in 1937. He's the son of the founder of the Swift Meatpacking Company. And his will provided the net income shall be paid to the lawful descendants then surviving in equal shares per stirpes of my deceased son Alden B. Swift and said Lydia Nyblack Swift. To the lawful descendants then surviving. Seems clear enough. Alden and Lydia had 3 kids. Lydia, Nathan, and Narcissa. And Nathan Sr. had a son, Nathan Jr., and a daughter, Martha. Okay, it becomes less clear now when we look at some more facts. Martha, was Nathan Jr.'s older half-sister. So Alden was not Martha's biological father. They did have the same mother, but Nathan Sr. adopted Martha when he married the mother. All right, and then they had the little Nathan Jr. Martha was 14 at the time that Nathan Sr. adopted her. All we really need to know is that Martha was adopted. So now the case really is about statutory construction and when a statute can apply retroactively. Remember, this trust, I think, was made in 1936. Statute was enacted in 1975. And it's also about when testamentary language demonstrates something by clear and convincing evidence. So what was it that the will needed to show by clear and convincing evidence? It needed to show that Lewis Swift Sr. intended to exclude his adoptive great-granddaughter Martha, or that he intended to exclude any adoptive descendants. So what language suggests that he meant to exclude her? Per stirpes and lawful descendants. Okay, whoa, come again? Remember per stirpes? It meant that we divide the estate at the children's level. And it's if you think about a picture of grapevines, I should put a picture of grapevines right here. Think about grapevines, and sort of going biologically down the vine. Okay, and lawful descendants. I still don't know what that means. Well, is there any precedent? Yeah, there was. There was a case, Continental Bank, that said descendants meant only blood offspring, and per stirpes therefore excluded adopteds. There was also a dissent in that case, and it said that these don't show anything. There's not even any indication the testator thought about adopted heirs. That's more likely to be the case. And so if the testator didn't even think about it, we certainly can't say this is clear and convincing evidence, and we should apply the presumption. The court here holds that per stirpes and lawful descendants are not clear and convincing evidence of an intent to exclude adopted heirs. All right, so this case goes in Martha's favor, but it raises this question that, class issues and survivorship issues are similar in that we're often asking whether the testator explicitly excluded someone. Often we're trying to figure out whether the testator's words mean something when it's likely something testator didn't even think about. All right, here's my side notes. Lewis F. Swift was the son of Gustavus F. Swift, I forget what the F means now, who founded the Swift Meatpacking Company. Lewis became president of the company. Gustavus, the father, once bragged that his slaughterhouses had become so sophisticated that they used everything but the squeal. There's an old refrigerated truck. One of the reasons that they became so successful was that refrigerated trucks were invented and they were able to use them. So that's the end of this segment. Thanks a lot.